Namaskar. In this video, I am going to explain the salient features of Mines and Minerals Development and Regulation Amendment Act 2025. The Parliament has passed the amendment of MMDR Act on 12th August 2025, in which main features which were taken up for amendment are mineral trading exchange to be created for fair valuation of minerals on trading. The second major amendment was for deep-seated mineral, a 10% additional area is now allowed for existing mining leaseholder and 30% area is allowed for composite licenses. The removal of 50% selling by captive leaseholders has been removed. Now, captive leaseholder may sell the complete minerals subject to payment of additional amount. And now the government has allowed dump selling by the state government on payment of certain amounts. The objective of National Mineral Exploration and Development Trust is widened. Its scope has been increased. And another important amendment was the prior approval from the central government in case of composite license grant of notified minerals like iron ore, bauxite, manganese, and limestone. It is done out. A new amendment of inclusion of new minerals in existing lease area has also been allowed. Mineral exchange, a new definition was made. Mineral exchange means an electronic trading platform or a marketplace registered in accordance with the provision of these Act, where buyer and seller of minerals is concentrate, including any form, including metal, they can transact and trade and enter into a contract for marketing. So government proposed to build a mineral exchange trading platform. It will be endeavor of the government to propose to build a trading platforms by notification in the official gazette, and there will be provisions for registration of mineral exchange, regulation of all aspect of activity of the mineral exchange, maintenance of that trading platforms, and fees and levy of mineral fee. It will be just like a MSTC. So a mineral trading platform will be established by the government. Then for maximization of the recovery of deep-seated minerals or a mineral blocks in the boundary area, now government has allowed the existing leaseholder, they can get a additional continuous area up to 10% of existing lease in a one-time period of entire lease. Similarly, for in composite license, the extended area may be up to a 30%, and government may extend such ML or CL area and include in the existing lease with certain conditions payment of additional amount as may be prescribed by the central government. And the deep-seated mineral means the mineral which is occurring at a depth of 200 meters. So this has also been clarified in this amendment. Another important, till now, captive lease holders are allowed only 50% of their selling after meeting the annual requirement of plant linked with the captive lease. Now this 50% selling has been removed and they can sell the mineral as much as they can, but with additional payment as prescribed under 6 which is equivalent to royalty or 1.5 ton times of the royalty. Along with this, another amendment is state government is allowed to sell the dump which has been staked up to such date on payment of a specified amount as mentioned in the sixth schedule. So this 50% limit and overburden waste dump selling provision has been included in the amended MMDR Act 2025. Objective of National Mineral Exploration and Development Trust is extended. Now this fund can be used for exploration of the offshore area and also exploration outside of the India. Means this fund can be used for exploration in the foreign countries. Earlier, there was a condition for notified minerals while granting a composite license. State government was required to seek a prior approval from the central government. So this prior approval system has been removed for grant of for auction of composite license of a notified minerals, iron ore, bauxite, limestone, and metals. So this prior approval system by the state government has been removed. Inclusion of new mineral in existing lease allowed. Suppose existing lease is there and a new mineral is discovered, so this provision was not there earlier. Now the leasee can apply if they discover a new mineral in addition to the mineral which is existing in the lease. They can apply and state government may include that mineral within the 60 days time period and they have to pay the additional amount as scheduled in the Act schedule. So provision of any minor mineral is also included, which can be included in the major minerals, and major minerals can also be included in the minor minerals. So this inclusion provision of new mineral is earlier leaseholders were reluctant, even though they were getting new minerals, they were not reporting. So for this to streamline the things, a new provision has been made in the Act. This is the Act schedule, as I told, for auction cases, while inclusion of mining lease, there will be a no additional charge. For non-auction cases, for critical minerals, there not be any charge, and for other minerals, which will be equivalent to the royalty. So, any additional minerals can be, if it is found, then can be included in this area with additional charge as mentioned in the Act schedule.